Discharge, and Remedies. Section Objectives. 1. To identify the primary methods of discharging contracts. 2. To recognize the primary legal remedies available for breach of contract. And 3. To recall the primary equitable remedies available for breach of contract. Contract discharge. Performance is the most common way to discharge contractual duties. Sometimes the duties are absolute and sometimes they're conditional. A duty is absolute when you have to do it right now. Duties are conditional when there is some condition that either precedes the performance or brings it into being, or terminates the performance or causes it to end. Let's talk about conditions of performance for a moment. Sometimes performance is conditioned on a certain event. If the condition is not satisfied, the obligations of the parties are not discharged. There are three types of conditions that we have to talk about. The first is a condition precedent, a condition that must be fulfilled before a party's performance can be required is a condition precedent. Easy example. If I hit Powerball this Saturday, I will give everyone in class an A. Now, in order for me to have to give you an A to keep my promise to bring the contract into being, I have to hit Powerball. If I don't hit Powerball, I don't have to give you an A. My hitting Powerball is a condition precedent, a condition that brings my duty to perform into being. Next, we have a subsequent condition. When a condition operates to terminate a party's duty to perform, it's called a subsequent condition. Simple example. I hire you to play baseball for my team for 2 years. When the 2 years lapses, your duty to play for me is terminated. In this instance, the running of time, the 2 years lapsing, is a condition subsequent to your duty to perform. Our third and final condition is a concurrent condition. A concurrent condition exists when each party's performance is conditioned on the other's simultaneous performance. This is a fancy way of saying both parties have to perform at the same time. I don't have to perform for you until you start performing for me. You don't have to start performing for me until I start performing for you. Your performance is conditioned on my performance, and my performance is conditioned on yours. Now, the closest example I have for this is you buying groceries in a supermarket. When does the cashier give you the groceries? When you give the cashier the money. When do you give the cashier the money? When the cashier gives you the groceries. Pretty much those actions cross, right? They happen at the same time, causing the other party to perform. Discharge by performance. Most contracts are discharged by performance. This simply means by doing what was promised. In some situations, performance can also be accomplished by tender. Legal tender is any official medium of payment recognized by law that can be used to extinguish a public or private debt or meet a financial obligation. In other words, money. Now, with regard to contracts, there are two types of performance that the law recognizes: complete performance and substantial performance. We're going to start off talking about complete performance. Under the common law, complete performance is required to discharge a contract. This occurs when a party renders performance exactly as required. Any deviation relieves the other party of its duty to perform and will allow the party to sue for breach of contract. So this is very, very simple. This is very, very simple. Right? All it means is you do exactly what you promised to do. For example, I hire you to wash all of the windows in my building for $1,000. I happen to have 1,000 windows in the building. You accept my offer and you begin to wash the windows. 2.5 days later, you come to me and you say, Mr. Clare, the job is done. I've cleaned all the windows. Can I have my $1,000? And I say, wait 1 minute, let me go and inspect the work. So I go on and I look at the building, and you pretty much done what you promised to do. You've washed 999 windows, but there's one small window about the size of a notebook, a basement window behind a bush, that you missed. Now, because you failed to wash that one window, under the common law, you have not completely performed. You have deviated from your contractual obligation. And now I don't have to pay you, and even better, I can sue you for breach of contract. Complete performance is the highest standard of performance that the law recognizes. Next, we have substantial performance. Substantial performance is a term used in contract law to refer to a degree of performance of a contract which isn't full and complete performance, but so nearly equivalent that it would be unfair to deny a contractor the payment of the agreed upon price. If substantial performance occurs, the non-breaching party's duty to perform remains intact. However, its performance is prorated by what the breaching party did not do. Let's talk about substantial performance. I'd like to refer to the example that I gave regarding washing all of the windows in my building. Now, complete performance requires that you clean all 1,000 windows. Any deviation, as we stated, relieves my duty to perform or my duty to pay you. With substantial performance, the law requires that you do more than you don't do. So you have to do a minimum of 51%. Now, in this instance, you cleaned 999 of 1,000 windows. By any measure, you have performed substantially because you've done more than 51% of the windows in the building, right? So the law says that even though you didn't do everything you promised, my duty to pay you remains in force. Now, because you didn't do everything you promised, I don't have to pay you the full contract price, but I do have to pay you for the work that you did. Now, this example is very easy. I'm paying you $1,000 to clean all of the windows in my building. The building had 1,000 windows. That's $1 a window. You clean 999 windows, so I have to pay you $999. Now, had you cleaned less than 500 windows, you would not have substantially performed because 500 is 50% of 1,000, which is less than 51%. And in that case, my duty to perform, my duty to pay, does not remain intact. I'm relieved of that duty, and I can now sue you for breach of contract. Now, as I said, with regard to substantial performance, 51% is the minimum performance required. However, as a matter of fact, what constitutes substantial performance will vary based on the subject matter of the contract. With washing 1,000 windows, 51% would be substantial. If I were a dressmaker and I were making you a dress or a suit, if I made you 51% of a dress or 51% of a suit, would you have anything that's remotely usable? The answer is no. So in that case, the 51 would not be substantial, right? With regard to a dress or a suit, right, it might be something close to the 80%, 85%. Or you think about something that everybody but me can relate to, hair. I'm a hairdresser. If I do 51% of your hair, should you pay me for that? Have I performed substantially? Or do you look like Boo Boo the Fool? You look like Boo Boo the Fool. Now, material breach of contract. This is really important because if performance is not substantial, a material breach arises. When a material breach occurs, the non-breaching party is excused from performance and can sue for damages caused by the breach. If the breach is not material, the non-breaching party's duty to perform is only suspended until the breach is remedied. Let's go back to that first example I gave you, the building with 1,000 windows. You clean 999 windows, right? Now, there is no material breach because you have performed substantially. We have two situations, two things we can do here. I can give you the opportunity to remedy the breach, to go back and wash that one window, or I can elect to only pay you for 999 windows, right, and not the full 1,000 windows. Any breach entitles a non-breaching party to sue for damages, but only a material breach discharges the non-breaching party from the contract. Now, this is really important. If a party performs substantially, they did not perform completely. And while a material breach did not occur, a simple breach did. Now notice the two words, simple and material, simple and material. If the breach is only a simple breach, the non-breaching party's duty to perform remains intact. The non-breaching party has the option of prorating the payment given to the breaching party or allowing the breaching party to cure the breach. Only in a material breach, meaning that the party did not complete at least 51% of what was required by the contract, can a non-breaching party be relieved of his duty to pay, right? And you have to understand, the law tries very, very hard to be fair. And the reason why we have this distinction between a material breach and a simple breach, between complete performance and substantial performance, is because in the eyes of the law, you want to be fair. You want to pay someone for the work that they actually did, but you don't want to overpay them for services that were not provided. You want to be fair on both sides. Performance to the satisfaction of another. When the subject matter of a contract requires personal satisfaction is a condition of performance that must actually satisfy the party. The only requirement is that the party to be satisfied act honestly and in good faith. Real big example of this will be when you go to a hairdresser or when you have a photographer take a portrait of you. Now, when you go to your beautician to get your hair done, you must be satisfied with the job that they did. If you're not satisfied, you don't have to pay them. Same thing with someone taking a photograph for a family portrait. If you're not satisfied, you don't have to pay. Now, why does this work really, really well? Think about this. If you go to your hairstylist, your barber, or your beautician, and they make you look fantastic, don't you want them to do that again? Hopefully you said yes. If you want them to do it again, what do you have to do? You have to pay them. Now, if they make you look like Boo Boo the Fool, should you pay for that to be turned into a clown? The answer is no, right? And that's why this whole piece about honestly and in good faith works really, really well. People are inherently honest, and when something is good for them, they want a do-over. They want it repeated as many times as possible. Now, in contracts that involve mechanical fitness, utility, or marketability, the performance to the satisfaction of a reasonable person, right? A reasonable person. Now, when we talk about mechanical fitness, the standard of a reasonable person would be manufacturer specifications, right? An example of this would be you go to your mechanic and you take your smart car in there to be tuned up. And you tell your mechanic that you want your smart car to cruise at 135 miles an hour and to purr like a Maserati. Now, if you've ever seen a smart car, those ugly little cars that the cops have all around the college, you know that a smart car cannot, under any circumstances with the engine that it has, cruise at 135 miles an hour. So if you go there and you test drive your car and you say, I'm not satisfied because the car doesn't go fast enough, the mechanic only has to say it was tuned to the manufacturer's specifications. That's the reasonable person standard. Now, when we think about marketability, what does that mean? That simply means that a product or service is fit for its intended purpose. That's like going to a restaurant, you order a meal. The question is not does it taste good, although that's important to you. The question would be, is it edible? Because taste is totally and completely subjective. Now, I know what you're thinking. If you send food back, the restaurant always takes it, or if you don't like it, they won't charge you. The reason why they do this is not because the law requires them to do it, but because they don't want you to cause a scene in the restaurant and disturb other customers, right? Because the question is the food edible? If you order a well-done steak and it's a little too well done, can you still eat it? The answer is yes. If you ordered a well-done steak and they sent you out a piece of charcoal, then it would not be marketable because it would not be edible. Anticipatory repudiation of a contract. If before either party to a contract has a duty to perform, one of the parties refuses to perform, the other party is discharged. The anticipatory repudiation can be treated as a present material breach, and damages can be sought immediately. However, until this is done, the breaching party can retract repudiation by proper notice. Let's break this down. I hire you to bake me a cake next Friday. Next Wednesday, you call me up and you say you're not going to bake the cake. Well, you have refused to perform before performance was due, right? That is an anticipatory repudiation of the contract. Now, because you refused to perform before performance was due, I'm discharged from my duty to pay you. I don't have to perform either. Now, as soon as you refuse to perform, right, I can treat it as a present breach. When you refuse to perform on Wednesday, I can act like you did not do what you said you were going to do on Friday. I can do that right away, and I can sue you starting on Wednesday for telling me you're not going to do what you promised to do on Friday. Now, until I initiate the lawsuit, however, you can retract your repudiation. So you can call me up today and tell me you're not going to do it. And then tomorrow, you could call me up and say, you know what? I changed my mind. Yeah, you've retracted repudiation by proper notice, right? I changed my mind. I'll go ahead and bake the cake for you, right? Now we go forward with the contract, right? As long as I have not initiated a lawsuit because you already changed your mind. Discharge by agreement. Mutual rescission. Both parties can agree to discharge each other from their mutual obligations. Right? What does that mean? That means if you and I enter into a contract whereby you're going to bake me a cake next Friday, we can agree to cancel a contract. We don't have a problem with that. If you say you can't do it for whatever reason, I say that's okay. No harm, no foul. I'll just find somebody else. We can agree to cancel that contract. That's okay. Substituted contract. Parties can agree to a new contract in place of an original contract. All right, so I had a contract with you to bake me a cake for next Friday. And it was going to be a three-tiered cake that would feed, let's say, 20 people. On Tuesday, I find out that I don't have 20 people coming to my fair. I have 57 people coming to my fair, right? So I have to order a bigger cake. So I call you up and I say, I need the cake that you're making for me tripled in size. I don't need a three-tiered cake. I need a six-tiered cake. Actually, triple would be 9 tiers. I need a 9-tier cake. You say, okay, I can do that, but I can't do it for the price that I quoted. I said, no problem. Let's make it happen. So what do? We substitute a new contract for the original contract. We can mutually agree to do that. Accord and satisfaction. This is something that I'm sure you remember. Parties can agree that one party will perform a duty differently from the performance specified in the original agreement. After the new duty has been performed, the party's duty under the original agreement is discharged. And just to break it down so it sounds familiar to you, an accord is an agreement to extinguish an existing obligation. The satisfaction is the execution of the accord. As you will recall, this is frequently used by debt collection agencies, right? A person may owe $10,000 on a credit card. The debt collection agency calls up and says, look, you owe us $10,000. If you pay us $6,000, we will consider your debt to be paid off in its entirety. When you make that an agreement to pay $6,000 for that $10,000 debt, that would be the accord. When the check clears, the contract is executed. That's the satisfaction. Finally, we have novation. With novation, a new party is substituted for an original party by the agreement of all parties. A new party is substituted for an original party by the agreement of all parties. Now, I want to make sure that I'm very, very clear on this. Novation is not delegation. Novation is not delegation. A delegation would occur if I were a general contractor that you hired to build your house. I, in turn, hire a plumbing subcontractor to do plumbing work in the house. I have a contract with the plumbing subcontractor. You do not. You have a contract with me, right? The plumbing subcontractor is doing my work without your consent because your consent was not required. Now, with novation, you hired me to be a general contractor to build a house for you. I find out that I have too many jobs. I can't get to your house, right, in the time frame that I thought I could have, and I let you know that. But I said, you know what? My buddy Dave is a fantastic contractor also, right? Here's his resume. Here are his references. And I was wondering if you would let him take my place in the contract. If you would let him build the house for you instead of me. After reviewing his resume and after contacting some of the folks he worked for, you say, sure, no problem. He can do the job in your place. What's just happened? An original party, me, has been substituted in the contract that you and I had by the agreement of all three parties. You agreed to let me out, I agreed to go, and Dave agreed to take on the job. Now, if Dave screws up, Dave is liable, I am not. Now, if we go back to delegation, that plumbing subcontractor, if he screwed up, I would remain liable because I'm still in the contract with you, right? With novation, Dave has completely taken my place with your consent, so my obligation to you has been extinguished. And if Dave screws up, only Dave is liable, not me, because you let me go. Discharge by operation of law. First is contract alteration. An innocent party is discharged when another party to a contract materially alters it without consent. I give you a check for $10,000. You decide you'd like a little more money, so you add a zero to the check, altering it to say I owe you $100,000. Now, because you've altered this contract, because the check is a contract, it's my promise to pay you without my consent, my duty to pay is extinguished. I'm discharged. Statute of limitations. The UCC provides that an action for breach of a sales contract must be initiated within 4 years after a cause accrues. The period runs whether or not the party knows of the breach. I purchased a car from you that's clearly a sales contract, falls under the bounds of the UCC, and the car has a defective engine. The car had a defective engine the day I drove it out of your lot. I did not become aware of the defect in the engine for 47 months, 3 years, 11 months. 4 years and 1 week, I try and sue you for breach of contract. Well, guess what? The time has run out by 1 month. I was supposed to sue you as soon as the cause accrued, and that was when I drove the car off the lot. I did not know anything about it, right? I've lost my opportunity to sue you for breach. Now, this is the good part. If the obligor makes a new promise to perform, the cause revives. If in 4 years, 1 month, I called you up, the dealer, and I said, look, the engine to my car is defective. What can you do for me? And you say, don't worry about it, bring the car on in and we'll take care of it. Because you made a new promise to perform, guess what? I got 4 more years to sue you now. The cause has revived. Bankruptcy, bankruptcy, bankruptcy. A discharge in bankruptcy may bar enforcement of most of a debtor's contracts by its creditors. A partial payment of a debt after the discharge in bankruptcy will not revive the debt. Now notice it said most of a debtor's contracts. There's some debt that cannot be discharged in bankruptcy. Taxes under 3 years old, guaranteed student loan debt, and child support debt cannot be discharged in bankruptcy, but other consumer debt can be. Impossibility or practicability of performance. If contractual performance becomes impossible in an objective sense, the contract may be discharged. Impossible in an objective sense means it cannot be done under any circumstance. Situations that generally qualify include one of the essential parties to a personal contract dies or becomes incapacitated before performing. The specific subject matter of a contract is destroyed. You're buying my house from me, but my house blows up. There's nothing to buy. Or a change in the law renders performance illegal. It's something that I was allowed to do yesterday, but the law made it illegal today. And practicability of performance is a little bit different. If circumstances arise that make performance extremely difficult or costly, the contract may be discharged under the doctrine of commercial impracticability. The anticipated performance must become extremely difficult or costly. Circumstances of which business persons at the time of contracting are or should be aware of do not qualify. An event that makes it temporarily impossible to perform a contract suspends performance until the impossibility ceases. If the lapse of time and any changes in circumstances make it substantially more burdensome to perform, however, the parties will be discharged. So what exactly does this mean? Well, you have some situations that through no fault of the parties change the parameters of what you were going to do. Let's say I enter into a contract with you to provide a special kind of lumber from you for $200,000. This lumber only grows in one forest in Malaysia. Now the lumber is going to cost me $150,000 to procure. My profit is $50,000. After entering into the contract with you, before the contract can be executed, a civil war breaks out in Malaysia centered in this forest. Half the forest burns down. The supply of this lumber is cut in half. The price is double. What was going to cost me $150,000 now costs me $300,000. Now, once again, our contract is only for $200,000. Now, if I come to you and say, I can still do it, but you have to pay me more, and you say no, the contract has now become commercially impracticable. It's not impossible to do, but through no fault of my own, it's become extremely expensive to perform, and the court is not going to make me go bankrupt for something that is not my fault. Right now, was this a circumstance that I could have been aware of? The answer is no. How would I know that a civil war would break out, burning down half the forest where these trees grow? I couldn't have known that. That's not something I was aware of, right? So I will be covered. Legal remedies for breach of contract. Our first legal remedy is damages. Damages are a monetary compensation that is awarded by a court in a civil action to an individual who has been injured through the wrongful conduct of another party. Damages attempt to measure in financial terms the extent of harm a plaintiff has suffered because of a defendant's actions. Damages are distinguishable from costs, which are the expenses incurred as a result of bringing a lawsuit and which the court may order the losing party to pay. The purpose of damages is to restore an injured party to the position the party was in before being harmed. Now, there are four types of damages. Compensatory damages is a sum of money awarded in a civil action by a court to indemnify, compensate a person for particular loss, detriment, or injury suffered as a result of unlawful conduct of another. Compensatory damages provide a plaintiff with the monetary amount necessary to replace what was lost and nothing more. Compensatory damages are generally the difference between the contract price and the replacement cost. Compensatory damages are the standard measure for awarding damages for contracts dealing with the sale of goods and contracts dealing with the sale of land. Now, very straightforward, right? With both these instances, it's going to be the difference between the contract price and the replacement cost. I offer to sell you a car for $5,000 after entering into the contract, but before executing the contract, I changed my mind. I don't want to sell you the car. I'm now a breach of contract. You, however, still need a car. So you go and you look for a car to replace the one that I was going to sell you. The next best price you can find for a car that is similar to the one you're going to buy from me is $7,500. So you buy the car. You sue me for breach of contract. And if you win, the court would order me to pay you $2,500. Now, $2,500 is the difference between the contract price, the $5,000 car I was going to sell to you, and the replacement cost, the $7,500 car you bought from someone else. Now, the idea is you get the benefit of the bargain. It's not to punish me for breaking the contract. It's just to make sure that you get what you would have gotten from me for the same price. Now, it is very, very straightforward. The only time things get a little interesting is when you deal with construction contracts. Now, with construction contracts, you have two parties. You have the buyer/owner and the builder/contractor. Let's talk about the buyer being the breaching party. If the buyer breaches a construction contract after the contract was entered into, but before construction had begun, the builder is entitled to profits. How does this work? Let's say I'm a general contractor. You come to me to build a house for you. The contract we enter into is $300,000. Now it's going to cost $250,000 to build the home. My profit's going to be $50,000. Now, if you breach this contract before I start to do any work on your house, you owe me $50,000, my profits. Now, this might seem strange, it might seem unfair, but it's very, very fair. Why? The time I wasted with you was time I could have spent with someone who'd actually go through with the contract, who would have built the house, so I'd have earned that profit. If you did not have to pay me my profit, you've just wasted my time, and time is money, right? So I'm entitled to being paid for the time I wasted with you. Now let's say that the buyer waits until construction has begun to breach the contract. Very simple. The builder is entitled to profits plus costs. Profits plus costs. All right, so that $50,000 that the builder would have made by building the house, he gets that. Now, if he's halfway through the house it was going to cost him $250,000 to build a house, he's entitled to another $125,000 or a total of $175,000. The $50,000 profit plus its $125,000 cost. Now, if the buyer waits until construction is complete to breach the contract, the builder is entitled to the entire contract price. And the rationale should be very obvious, but the builder did everything he promised to do. Now let's switch gears a little bit. Breach by the builder / contractor. This is very, very easy. Whether the breach occurs before or during construction, we go back to our original equation. Damages would be the difference between the contract price and the replacement cost. Right, so let's say I enter into a contract with a builder to build a house for me, $300,000 home, construction to begin in 2 months. 2 months comes, nothing happens. 3 months come, nothing happens. The builder is in breach of contract. I still need a place to live, so what do? I hire another contractor. Now, because with construction in particular, prices have a tendency to fluctuate in an upward trajectory. It's not going to cost me $300,000 to build this house anymore. It's now going to cost me $325,000 to build the house. So when I sue the builder for breach of contract, what would he have to pay me? $25,000, the difference between the contract price and the replacement cost. And once again, it puts me in the exact same place I would have been in had the builder done what he promised to do, spending $300,000 for a home, right? The difference comes from him, so I'm in the same place. Now, before I move on, I want to talk about incidental damages for a second. And the reason why I bring this up now is because these are not standalone damages. Incidental damages are damages that are caused by expenses incurred as a result of a breach. For example, I hire you to build a home for me. You breach your contract. You don't get the home done in time. In anticipation of moving into my new home, I sell the home I already live in. Now, while it is true I found another contractor to build a house for me, right, it's going to take an additional 2 months before I can move into the house. During that 2-month time period, I have to stay in a hotel. Incidental damages would be the cost of living in the hotel. Incidental damages would be the cost of buying food from restaurants. Incidental damages would be the price of gas if the hotel is further from where I work than my house, and the wear and tear on my car for the additional miles that I put on it. Right? I get to add all of these damages to the lawsuit, and when I sue for compensatory damages, I would also sue for incidental damages. Excuse me. Important point. Incidental damages are not standalone damages. You have to be suing for something else to get incidental damages. The next major damage type is consequential damages. Consequential damages are foreseeable damages that flow from the consequences of a breach, but that are caused by circumstances beyond the contract. In order to recover, the breaching party must have known or had reason to know that special circumstances would cause the party to suffer additional loss. Consequential damages give the innocent party the whole benefit of the bargain. By way of an example, let's say I'm a nightclub owner and you are an interior designer. I hire you to redesign my nightclub. Now, in the construction contract, there's a clause that says that the work must be complete no later than July 1st. That's in the contract. You agree to it. You assure me that the job will be done. So in anticipation of opening up my club, I start to advertise a party for the 4th of July. I advertise the party, I hire new staff, I buy supplies, I hire a band and a DJ. Well, July 1st comes and goes. August 1st comes and goes. September 1st comes and goes. You finish my club on October 1st. Now here's the thing. Did you renovate the club? Did you redesign it? The answer is yes. Did you do it on time? No. Did I suffer additional loss because you did not finish as per the specified time, the date? The answer is yes. What did I lose? Well, obviously, I lost the money that I spent in marketing. Obviously, I lost the money that I spent in hiring a band and a DJ because I had to pay them, right? Perishable supplies like food, right? That's spoiled. I lost that. Now, the alcohol and sodas, that's still good because that lasts. But you know what the biggest loss I had was? The loss of income from being closed. And all of these will be the consequential damages that I would sue you for. Now, I know what you're thinking. How could anybody know how much money you would have made by being open? Well, it's very simple. You would look for clubs that are similar to my club, catering to the same market in the same area. And you would look to see what their revenues were over the time period I was closed because you didn't finish on time. And that's what I'd be entitled to, the average revenues of those clubs. Punitive damages. I like this word. Punitive means punishment. Punitive damages are designed to punish a wrongdoer and to deter similar conduct in the future. They are not generally awarded in a breach of contract action unless a tort is also involved. Now, I think about something like New York City entering into a contract with someone to build a water purification plant for the city. Now, this contract has very specific specifications in it in terms of, the filtration systems that have to be used, how much water has to flow through the pipes, the specific kind of pipes and materials that you have to include in the construction. Why? Because the health and safety of New Yorkers are on the line here. So the contractor enters into a $20 million contract with us to build this plant and completes it on time, no harm, no foul. But when I send the city engineers in to look at the plant, lo and behold, they've substituted many things. The filtration system that we ordered is not there. The one that they bought is substandard but cheap. They did it to save some money. They didn't put in the right kind of pipes. The diameter is too small, right? And their pipes that corrode, contaminating the water. They did not do what they promised to do. So we sue them for breach of contract, right? So the first thing we're going to get from this, we're going to get compensatory damages because somebody has to go in and build the correct filtration system, right? And that's probably going to cost a bit more money. So we're going to get the difference between the contract price and the replacement cost. We're also going to sue them for consequential damages. Why? The purpose of this water filtration system was to provide New Yorkers with water. And in the interim, we've got to get water from somewhere else. That's going to cost money. They should pay, not the city. And finally, they committed fraud. And I'm sure you remember, fraud is a tort. They said they were putting one thing in, and they put something else in. They lied to us. So we're going to sue them for punitive damages. So let's say the consequential damages is another $10 million. The compensatory damages is another $10 million. So far, we got $20 million we're suing them for. Well, in order to punish them and to deter similar conduct in the future, the punitive damages are going to be $100 million. So we're going to sue them for a total of $120 million. Now, once again, punitive damages are designed to punish and, more importantly, to deter similar conduct in the future. Very important. Now we come to nominal damages. Nominal means small. A small monetary reward, often $1, granted to the plaintiff when no actual damage was suffered. Basically, nominal damages just establish that the plaintiff was right and the defendant was wrong. They suffered no financial harm, so they're really not entitled to anything, because if they were, they'd be unjustly enriched. So this just establishes that the plaintiff was right and the defendant was wrong. No more, no less. Now, the injured party has a duty to mitigate damages. Mitigation of damages is a requirement that the plaintiff do whatever is reasonable to minimize the damages that are caused by the defendant's breach. Now, the operative word here is reasonable. You don't have to do anything excessive, right? Now, an example of the mitigation of damages, let's go back to the example that I gave you early on. I offer to sell you a car for $5,000, and then I change my mind. I'm in breach of contract. You still need a car. So since you know you can sue me for compensatory damages and get the difference between the contract price and the replacement cost, you decide, as opposed to buying a $5,000 car, you're going to go and get yourself a $65,000 car, knowing that I'll have to pay the difference between the contract price, $5,000 for me, and $65,000 for the replacement car, or I would have to pay $60,000 for your car. Well, that seems like a good idea, but no, because that's not reasonable. If you were buying a $5,000 car, the replacement you look for should be within a reasonable range of $5,000. Now, nothing crazy, which is why if the next best price, notice what I said, best price you could find was $6,000, that'd be okay. If you couldn't find one for $6,000, but you found one for $7,000, that would be okay, because that's reasonable. That's the next best price. But there's a huge gap between $5,000 and $65,000. How many cars are in the middle of that, right? So you have to take reasonable steps to limit the harm that you suffered, right? That's all the mitigation of damages means. Now let's talk about liquidated damages versus penalties. A liquidated damages clause is a provision in a contract that specifies a certain amount to be paid on a default or a breach. A penalties clause is a provision in a contract that specifies a certain amount to be paid on a default or a breach. Now, I hope you've noticed they say the same thing. Now, a liquidated damages clause is enforceable, but a penalty is not, even though the wording is identical. In order to determine whether a clause is a liquidated damages clause or penalties clause, you have to ask two questions. First, at the time the contract was formed, was it apparent that damages would be difficult to estimate in the event of a breach? Second, was the amount set as damages a reasonable estimate or excessive? If the answers to both questions is yes, it's a liquidated damages clause and it would be enforceable. Let's say there was a real big event coming up in August. Great big concert. Favorite acts are there. And you, being an entrepreneurial business major, decide you want to make some money. So you decide to design and manufacture some t-shirts to commemorate this concert. Right? So you design them and you go to a t-shirt manufacturer, right? And you buy 2,500 t-shirts, right? And they have to be completed no later than August 1st. This concert is going to be on the 5th. Now, in the contract, there's a clause that says if they are not completed by August 1st, that the manufacturer has to pay you $50,000. Now, you've spent $5,000 on these t-shirts, all right, these 2,500 t-shirts. Now, here's the thing. If the concert is a really great concert and people have a great time, they'd be willing to pay a premium for these t-shirts. You might be able to sell them for $50 a shirt. If the concert sucks, you probably have to settle for $10 a shirt. The point is, today in May, you have no way of knowing how much you'll earn. Now, here's the question. Is that clause in a contract, the damages clause for not delivering on time, a liquidated damages clause or penalties clause? Let's ask the questions. At the time the contract was formed, April 6th, was it difficult to estimate the damages that would be incurred on a breach? I'd have to say yes to that. You have no way of knowing. Question 2, was the amount set as damages, $50,000, reasonable or excessive? Well, let's see, $2,500 shirts on the low end, right? If I sell the shirts for $10 a shirt, that'd be $25,000. On the high end, if I sell them for $50 a shirt, that would be in excess of $100,000. Now, $50,000 is in between the two, so that's probably reasonable, right? Because I might make more than that, even though I might not. So it's reasonable because it's about mid-range. Now, if I said you had to pay me $250,000 if you don't deliver them on time, that would be excessive, and the contract would not be enforceable. Lastly, we come to specific performance, and this is very, very simple. Specific performance is an equitable remedy in which a court orders the parties to perform as promised in the contract. This remedy is normally only granted when the legal remedy, monetary damages, would be inadequate. That simply means that the only time the court will order specific performance is when the subject matter of the contract is either unique or extremely rare. That means that there's no replacement. For example, I'm going to sell you a Van Gogh painting for $5 million. After into the contract with you, I change my mind. I don't want to sell the painting to you. In a case like this, even if the court ordered me to pay you $100 million, could you buy the painting? The answer is no. Why? It's unique. So what would the court do in this instance? They would order me to do what I promised to do, sell you the painting for $5 million. This concludes contract law.